I salute you all. Thanks for being on and thanks for watching. So basically, we are under the law of contract one basically. And under contract one, we are looking at elements of a valid contract. And basically, we are going to look at acceptance as an element of a valid contract, acceptance. So basically, when you look at contract law, for you to understand it, for it to be a valid contract between the two parties, there must be a valid acceptance. Understand? And we are going to see what amounts to a valid acceptance, what does not amount to a valid acceptance. So basically, acceptance in the layman's understanding is like a reply to someone's offer or to someone's request. You get? What you have to know, acceptance is defined under Section 2 of the Contracts Act, which means that it is an assent to an offer made by the what? By the offerer. You get? It's like an assent. So basically what you have to bear in mind, or what you have to put in mind, is that here the offeree sends in a reply or sends in something agreeing on the terms or the conditions of the offerer. Get? So note that in mind. And acceptance has particularly rules that govern it. You get? Basically what you have to know, that acceptance has various legal rules or regulations that guarantee it to be valid. First of all, acceptance must amount to a final and unqualified assent to the terms of the offer. It must be final. And acceptance can be by words or by actions. You get? You can reply by words or by your act. You get? If at all I tell you that paint there, I'll pay you, even though you don't reply me, but if you do, you start the painting, it implies that you have what? You have accepted my offer. So note that in mind, or bear that in mind. So when you go to the communication of acceptance, that is under Section 4 subsection 2 of the Contracts Act, talks about communication of what? Of acceptance. Basically here they say that acceptance must be communicated from the offerer to the from the offeree to the offerer. You get? So the offeree must communicate his acceptance to the offerer. So the onus is on the offeree to communicate whether he has accepted. And you have like principles that guide the communication. The communication of acceptance must be against the offer, must be against the what? Must be against the offeree. The offeree. And once it is in the course of transmission, it must be against the what? Or it must be out of power of the acceptor. So that is a valid communication of acceptance. Or it must come to the knowledge of the what? Of the offerer. Once it comes to the knowledge of the offerer, it becomes a valid what? Acceptance. Or once it is in transmission and it is out of power of the acceptor. So note that in mind, following Section 4 subsection 2 of the Contracts Act. So when you go to, in addition to the communication of acceptance, communication of acceptance can also be made by post. That is the postal rule. Under the postal rule, once you put a post in the post office, realize that that is a valid what? Acceptance. Even though the offerer hasn't received your acceptance, you have already communicated. That is by post. That is the only exemption under communication under the postal rule. Once, take for instance, if someone sends you a letter, or he tells you that I want to sell you this and this, he has made an offer. For you, your reply, you make it by post and you post it in the postal office. So even though he receives the letter next week, for you, the moment you post the letter and you say that I post my reply or my acceptance, the contract is valid. That acceptance is valid. Regardless whether he has got information or not, the acceptance is already what? Valid. You get? So once he breaches, is liable. You get the point. Once he breaches, is liable. You can not say that I had not received your acceptance. What I want, for me, I posted and that was enough. It was a valid communication of my what? Acceptance. That is the postal rule. You get, but the onus is on the acceptor to post that letter in a rightful manner. You must post it there. Just not leave it. Even if you must not just leave it to the tailors, what and what. You must make sure you have posted it, and it must have the clear address of the offerer, because it is they are delivering to the offerer's what? Address. It must have a clear address, so not that in mind about the postal rule. You get, for it, there's no need of it coming to the knowledge of the what? Of the offerer. So long as you have posted, the court presumes that the offerer will get knowledge afterwards. But communication is what? Is done. That is under acceptance. You get, under communication of acceptance. So not that in mind. So when you go further, when you realize that there is also what silence does not amount to acceptance. What do they mean that silence does not amount to acceptance? When someone makes an offer and you remain silent, it does not presume that you accepted. You get, so silence does not amount to acceptance, not that in mind. So that's it. When you read the case of Feldhaus versus Bindley, where court held that there was no valid what? Acceptance under that case. So not that in mind. Silence does not amount to acceptance. You must act, or you must stay expressly say the word. You get. But if you remain silent, then that does not guarantee that you accepted. So not that in mind. Silence does not amount to acceptance. Then when we go to revocation of acceptance, when can acceptance be revoked or be withdrawn? When you read section 5, subsection 2, says that acceptance can be revoked at any time. You get, at any time before it comes to the knowledge of the what? Of the offerer. You get, so not that in mind. Or before it comes to the knowledge of the, or before communication of what? Acceptance is complete, or before it comes to the knowledge of the what? Of the offerer. So it can be revoked at any time. So not that in mind. Then we also have Section 8 of the Contracts Act. When you read Section 8, acceptance can also be made by performing conditions, particular conditions to the offer. For example, I'll use the case of Khalil versus Carbolic Smoke Ball Company. Under that case of Khalil versus Carbolic, realize that Khalil accepted through performing conditions that were put up by Carbolic Smoke Ball what? Company. So the mere fact of performing conditions put on an offer, it amounts to acceptance. So not that in mind, or bear that in what? In mind. So basically that's the brief that I can talk about acceptance as an element of a valid what? Contract. Thank you for listening and stay blessed.